Demand for dismissal, part 3. This could be quite long, man. I'm halfway through this right now. Point 28. When Cheryl's JAG officer attorney asked her where the alleged liens were that were allegedly filed in Davison County, because see, that's what it said, where we filed in Davison County, Tennessee. Cheryl had not stepped down from her administrative office position in her court martial. So this attorney's asking her, where were the liens filed? Right? So she should have stepped down because now she's becoming a witness. Office position in her step down for administrative officer position in her court martial. See background, yellow fringe flag. Gave unsupported and unsubstantiated testimony that she did research in the UCC and determined that the UCC1 financing statement is a lien. Okay. Following a logical and common sense path, the JAG defense attorney should have at least filed a subpoena, ducis tecum, against Cheryl for the alleged UCC1 section supporting her declaration. Cheryl's JAG officer attorney accepted her declarations as if it were law. Furthermore, following due process of law, before Cheryl can give testimony as a witness after the fact, she is required to step down from the bench, be sworn in as another witness, and open herself to be properly examined and then cross-examined under penalty of perjury. To the contrary, however, Cheryl used her position to declare her fraudulent testimony contrary to proper judicial conduct, and then ordered her cohort JAG officer attorneys to continue the court-martial jury trial on to my injury or our injury. JAG officer administrator Cheryl A. Blackburn did declare as testimony that the UCC1 financing statement is a lien. And as such, it is fraudulently labeled as a financing statement, okay? If she's saying that this is a lien, then it's not a financing statement. By the Tennessee Secretary of the State's office, as well as the UCC itself. And if Cheryl is correct, then listen to this, y'all, then every UCC1 financing statement filed in this and every other state of the Union, the District of Columbia, every state of the United States, every territory of the United States, and such has committed fraud by falsely titling said forms as something other than a lien, and that the duplicitous lien from already filing is required with the UCC1 financing statement. She's saying that this isn't a financing statement, that it is a lien. And I'll get into that. That has to do with, I'll get into that in just a minute, into this document. So kind of keep that in the back of your head for now. I state that any liens I might have written in this world were based on a common law contract and mailed utilizing the postal rule and therein lawful. I read this in one of the earlier videos here, or most recent videos. The ability. This is United States Supreme Court, 1969, Snydash versus Family Finance Corporation. Okay, when they say, well, you have to have legal basis to do a lien. No, you don't. Not according to the United States Supreme Court. And this is a quote: the ability to place a lien upon a man's property, such as to temporarily deprive him of its beneficial use without any judicial determination of probable cause, dates back not only to medieval England, but also to Roman times. Look, folks, you do not need anybody's permission. Somebody made a comment on one of the last ones that I did. I thought you said you can lien anybody. You can. He was making a comment like he was suggesting that you can't lien any. Well, wait a minute. I thought you said you can. Yes, you can. You can lien anybody, and you don't need any judicial determination or probable cause to do it. Listen, folks, I'm speaking to each and every one of you listening personally, straight up, face to face. If I want to lien you, I can lien you. I don't even, all I need to know is who you are. Your address or whatever. Bam, you're hit. Okay. Since the trial tribunal failed to produce evidence to lawfully invalidate the underlying contract that has since been lawfully validated by the bankruptcy tribunal, the officers of the trial tribunal, along with the sheriff's office, Davidson County Sheriff's Office, a corporation, the TBI, a corporation, the FBI, a corporation, as well as the commissioner of the Tennessee Department of Corrections, a corporation, and the CEO of Core Civic. I had to add them in there. I was never in a Core Civic prison, but my friends were. The Court of Criminal Appeals, which is a corporate entity, and now you, the Supreme Tribunal of Tennessee, all of which are corporate entities having trespassed upon our contract. We had contracts. Every one of them is trespassed on it. Kidnapped 10 people who are exercising their constitutionally secured rights, and therein you all should be charged with not only kidnapping, but also treason and conspiracy, and among other crimes against us. Inter alia. In your majority opinion, if you guys have the opinion, you can look this up for yourself. On page 4, paragraph 4, line 6, wherein it states, a claim of lien based on a concocted contract or lien, as well as page 18 under description of the language of the UCC1s, wherein it states that claim of lien is based on a common law contract. Then it gives the certified mail and return receipt number. This shows proof that not only did you know that the liens were based on a contract, but you disagree with their validity, according to the bankruptcy tribunal, based on the term you use, concocted. So they knew that it was genuine. It was validated through the federal tribunal, and then they went on ahead and said that this was concocted. They knew this. They knew it. Suggests that you have read the contract, because you use the word concocted. And here, concocted, I read it just yesterday or day before. Concocted is a clinical term meaning to prepare food or drink by mixing a variety of ingredients, figuratively to make up, devise, obsolete to prepare with heat as by cooking, boiling, or baking, to digest. Concocted. Suggests that you have already read the contract and is now part of the record. Yet it was apparent that the trial tribunal knew that the JAG attorneys motioned for a new trial hearing when they learned of the bankruptcy by Melissa Hauser, and that's my ex-wife, y'all. That should have been the end of this unlawful and treasonous conviction, due to the fact that the contracts were now validated, and then no trial would have been necessary due to the contracts being legal basis for liens. Therefore, all liens, UCC1s, and contracts were lawful, and those debtors had their opportunity to fulfill the conditions of the contract or otherwise address the contract lawfully, but they did nothing and said nothing. Therein, mutual assent was given by the contractees, and the contractees are therefore valid, or the contracts are therefore valid and in full force, IAW, with common law, contractual law, UCC, and trust law, making Roger A. Page doing business as Chief Justice of the Supreme Court, a conscriptor and malfeasant, unless you make a right ruling and dismiss this bogus action immediately. We're blasting them, but we're giving them a way out. A lot of this stuff is going to be brought up in post-conviction, and then some. I ain't threw down all my cards. So we're about halfway through a hand of Texas Hold'em. I declare that your opinion is wrought with fraudulent declarations, such as page 3, paragraph 4, wherein it states, whatever the reason, none of these victims had business dealings or contractual relationships with the defendants. When the alleged victims are public officials, public servants, and are therein held by contractual obligations per the Tennessee Constitution and the Constitution for the United States of America. To be clear, in the court-martial jury trial, there were several witnesses for the state that testified to the fact that they only knew some of us from an action in their tribunals. Then they stated that they had no business relationship with us, but they had received a packet in the mail. Clearly, the county is conducting business as the circuit court is doing business for the county, all under the color of law. Most of y'all know the definition of color of law, so I'm not going to regurgitate it. They can contract and be contracted with. In other words, doing business, which implies a business relationship. 51, Tennessee Code Annotated 5-1-103, corporate capacity states, every county is a public corporation. Tennessee Code Annotated 5-1-123, General Sessions Court, empowered to enforce county rules. Tennessee Code Annotated 62201, 4, contract and be contracted with, and 5, incur debt by borrowing money or otherwise. So they're doing business, man. They are in business. They are a bank. Let's create some bonds. Only banks can create bonds. Or financial institutions, let me say it that way. Even Title 27 CFR, and I've spent a lot of time reading 27, man. Some great stuff in there. Subpart B, definitions, subsection 72.11, commercial crimes, states that any of the following types of crimes, federal or state, Offenses against revenue laws, burglary, counterfeiting, forgery, will be treated as if such were commercial crimes, implying that any crime or any criminal act is considered an act of commerce and therefore creating a business relationship. Next, on page 4, this is the opinion. On page 4, paragraph 2, Mr. Burton noted that persons who file the UCC 1-1 must state they are authorized to make the filing, and they must also acknowledge that it is a felony to file financing statements without an underlying debt. I'll get back to that here in just a minute. When I filed my first financing statement, when you went to the website, the Secretary of State's website, it didn't say anything about, there wasn't no forewarning, like there is when we did it as the class action conditional acceptance. So from the time we started doing these, there wasn't any notice on their website that this was a violation. 39-17-117, filing a false lien. But by the second time we were going in there, they had it posted right when you open up a financing file to do a financing statement. It had it right up there. It had the Tennessee code right up there. So there was no notice on the website when I did it for the child support issues, which was my ex-wife, the one she filed in bankruptcy. By the time we'd done the second one, they were already noticing it. They actually started putting it on the website. So really they could have argued that the liens that we did prior to them posting that on there, we weren't noticed that it was a crime. Now they're saying it is. That was ex post facto. So 12 of those, was it 12 or, yeah, I think it was 12. 12 of those charges, or 24 of those charges, should have been dropped immediately because there was no notice of it. Now you're going to put a notice that it's a crime. So, yeah, man, they screwed up all kinds of places. Footnote 4, see Tennessee Code annotated, 39-17-117. Also, paragraph 3, Mr. Burton described the remedy for an alleged debtor in the event of a contest or contested UCC1. Individual who believes a lien asserted against them is in a UCC1 is not valid may submit an affidavit contesting it. Once that is done, it has statutory authority to void the UCC1 filing. So anytime, actually, y'all, because of what Tennessee did in the state of Tennessee, anytime anybody liens you for anything, you can contest it. That's what we did. What we did caused the legislative branch of the Tennessee state government to enact this new thing where, okay, now you can contest a UCC. Before you couldn't contest a UCC1. Now you can. We screwed the state all up, y'all. We made them reconsider a lot of their stuff. Let's see. Once that is done, it has statutory authority to void the UCC1 filing. See Tennessee Code annotated 66-21-105. The alleged offense date is written on the judgment paper as of 10/16/16. That's when they said we committed the offense. Offense means when you hear someone say offender, really what they're saying is you made me mad. Look up the definition of offend. Therefore, the Supreme Tribunal has contaminated the record and their opinion quoting ex post facto statutes in order to support their overthrow of both the Tennessee Constitution and the Constitution for the United States of America. This supports that Jeffrey S. Bivens, he was the justice that wrote the opinion, acting as his trust, using Tennessee Code annotated from 2018 to credit his misdirection date of over 2 years after the alleged offense date, which is valid, or which is a violation of the ex post facto law and constitutional mandates. And in so doing, you have committed by your own ruling making false entry in books or records. The thing that they said, you remember one of the justices kept saying, I don't understand. What's this books or records? I can't get past books or records. Well, guess what? That's what you just did. And in doing so, you have committed by your own ruling making false entries into books of records, a violation of Tennessee Code 3914-114 B1B. With the intent to defraud or harm another, in violation of Tennessee Code annotated 3914-114A. On page 6, paragraph 2 and paragraph 4, this Supreme Tribunal declared falsely that each defendant filed a motion for a new trial and all the defendants appeared. We didn't file any motions for a new trial, nor did we appear. Remember, it's the usurped attorneys. The defendant sought permission to appeal to this court. We never asked for the appeals. Not a single one of us filed to appeal anything. You got to remember, they're doing this without any. That's why we're saying this is identity theft. I hereby subpoena Ducis Tecum and any documentation signed by me or us as a defendant seeking to appeal to this Admiralty Supreme Tribunal, in which I declare do not exist. That's why we didn't file, because we never once said we agree that this exists for me. This doesn't exist for me. It was, in fact, your JAG officer defense attorneys that filed for the appeals, never once having subpoenaed Ducis Tecum, the alleged liens allegedly filed in Davidson County, or subpoenaed Ducis Tecum the signed contracts that were served through the postal rule, creating common law contracts and filing a subpoena DT for a certified oath of office supporting that they have no obligation to we the people to honor and obey the Constitution, thereby giving up their individual sovereignty to become servants of the people. Okay, what Bivens' opinions, what Bivens' opinion rhetoric had written in the analysis is not whether we as humans filed these invisible liens per the charges, but merely a discussion on what a financing statement is, and not once did he prove that a UCC1 is in fact a lien, much less than say UCC1 or any actual lien documents was ever filed in Davidson County, Tennessee. Where are these alleged liens allegedly filed in Davidson County? But you did have a copy of the actual lien document filed in Washington, D.C. with the Treasury. They were holding copies that showed that these liens were filed in Washington, D.C., and they were trying to say that we filed them in Davidson County. Remember, Davidson County is a business entity. And so is the state of Tennessee. It's a business entity. And neither one of them are the same entity. Keep that in the back of your head while we go through this. Unless we factor in that Cheryl, the fiduciary, ordered the value fixed on the UCC1s when she was writing 204 times or 102 times. Every one of these financing statements went into an envelope. She wrote the number on it, the case number, and she wrote the amount, $4 million. Or 12 million. She wrote those on it. She gave them value. She fixed on the UCC, whereby altering the dynamics of the characteristics of the UCC, a non-negotiable instrument. The UCC1 is a non-negotiable instrument, into a fraudulent lien, a negotiable instrument, and then ordering said negotiable instruments filed into the case, whereby she, as a fiduciary, filed the fraudulent liens and committed forgery against us and the trust, along with gaining over $250,000 per lien UCC1 instrument for her corporate coffers. Okay, I'll finish up with that, but let me explain that in a little more detail. When she went up there and she called them liens, and then she put a price on them, she was basically negating the liens that we filed with the Treasury. She's saying those UCC3 filings, which assign the liens to the Treasury, they're not really the liens. It's the financing statement that's the liens. So she made the UCC1 filing statements a fraudulent lien that she can now file. It now is, it now has a, it's now a negotiable instrument. Now I can sell these. Because remember, she's acting as a fiduciary along with her cohorts. That's something to consider, folks. I will start with, on the next one, I'll start with some more about the opinion. This is coming closely to an end. I got about 10 more pages to go. So this looks like it's probably going to be about probably five videos altogether, or parts of videos. But anyway, y'all, thanks for hanging in here. Listening to this is understanding what really happened to us. And it's not that important that I'm trying to convince you to see things my way, as it is you need to understand or comprehend what it is they did to us so that you know what it'll be like when they do it to you. I'll probably do the other ones tomorrow and just put these 3 out today. But anyway, y'all, peace and blessings.